Kia ora koutou katoa. Ko John Edwards tēnei te mana matapono matatapu. Thank you for coming. I'm John Edwards. I'm the Privacy Commissioner. We are launching Privacy Week this week, which is 1 week of the year when we invite you to set aside and examine privacy amongst all the many other compliance and business priorities that you have. And we're really grateful to you for coming out and supporting this event to learn not just from me, but the perspective of other practitioners who've had the obligation of implementing Privacy Act 2020 in their workplaces. We are 6 months into the life of the Privacy Act 2020, which came into force on the 1st of December last year. It gave us mandatory privacy breach reporting obligations. And in the 6 months, we've had a doubling of reports through to our team that deals with those. We've had something like 230 reports filed through our Notify Us tool, of which approximately 1/3, we think, meet the threshold for serious privacy breaches. We've had an obligation on organisations to undertake some due diligence before exporting personal information. And that's caused some consternation, I think, and controversy. I'll be interested in the panel's experience of Privacy Principle 12 and the materials that we've produced to help particularly small to medium enterprises with that. There are new criminal offences. It's a criminal offence now to impersonate somebody else to get their personal information. It's a criminal offence to destroy personal information when it's been sought. We haven't prosecuted anyone. I haven't heard of anyone being prosecuted under these sections yet. And of course, COVID-19 has turned our world upside down in the last 12 months. I mean, we started off 2020 in my office thinking, okay, we've got business as usual, a pretty full plate, we're doing a reorganisation and a restructure, we've got new legislation to bring into effect, that's all good. And then suddenly COVID came along and upended all of our plans as well, and really came to the top of our agenda in terms of our work program. So with those introductory comments, I want to introduce our panel, our repositories of wisdom. Starting from the far end, we have Sarah Auva'a, a long-term privacy geek from Spark, and before that Telecom, and is in regular touch with us to keep us abreast of issues that are developing in the telecommunications world. We have Shera, Law Geek NZ on Twitter, and he is an advisor to many on a whole range of tech law, intellectual property, privacy and other matters, and founding partner of Lowndes Jordan, founding or just found? Law. Lowndes Jordan Law, yes. And finally, Sarah Thompson, who I think began her career at my office, and then spread her wings and provided expert privacy advice to Westpac, and now Air New Zealand has the benefit of her extensive wisdom. If you've ever used Ask Us on our website, privacy.org.nz, which is our FAQ, Sarah laid foundations for that. We've built on it since, but dedicated, I think, probably the last 6 months that you were with us to building that resource, and it's been excellent. It's built on the basis that you ask once and we can answer many times. I would encourage you to submit questions to us, to the panel, via the Slido platform. That's if you just open your browser and hit SLIDO, and it'll ask you for a code. It's PrivacyLive, all run together, capital P, capital L. And you'll be able to submit questions or upvote them, and that way we'll get a sense of what's important to the audience at large. We are live streaming this via Twitter, so if you want to send messages to anybody that you think wanted to come but couldn't make it in person because of the rain or the traffic or just because the agoraphobia, jump onto Twitter at NZPrivacy and follow that stream. Well now, each of the panelists has prepared a 5-minute opening statement Oh, did I forget to tell you about it? Sorry, no, they haven't. It's going to be quite conversational, so do start those questions coming through. I am interested in knowing what a large and mature, from a privacy perspective, organisation has done to prepare for mandatory notification. What systems you put in place to ensure that all the near misses and things are getting captured, directed to the right place, assessed, learned from, and fed back out into the organisation. So can I start with Sarah in the order that we introduce you? First, Sarah.
Thank you, John. So at Spark, we were fortunate that we're already in the practice of reporting data breaches or notifying our customers if we felt that there were concerns or steps that customers needed to take safe. But what we saw with the new law change was really the importance of scaling up and making sure that, one, we understood the broader definition of a data breach, which I guess in my personal view I still feel is exceptionally broad, so it captured a lot of things. And secondly, we wanted to make sure that we met the notification criteria of the Commissioner as well. And again, the materiality criteria, which I'm sure we'll discuss in more detail today, sometimes I feel can set a lower bar than is perhaps useful. But with that in mind, we set up an online data breach reporting tool. So what we wanted to do is make sure that all of our staff felt safe and knew how to use the tool and how to report any data breach or near miss. And we thought about asking staff to perhaps use the Commissioner's online assessment tool directly and decide whether to report. But we realised that asking somebody who's just experienced it or maybe caused a data breach or come across one to try to use the tool and assess the information objectively might result in over-reporting to the Commissioner's office and customers. So we have centralised the function, and we now have an incredibly useful tool and source of all of the data breaches that are happening at Spark, which sounds like we've got a whole lot, but many of them are what we call as minor email breaches. So we're doing a lot of education and so on. So it's been a great opportunity to really build it in the system and to get visibility about what's happening.
Do those come to you?
They do. Well, they come to my team, so, and the ones that are serious come to me. But we have a team of us that look at them and assess them. And
without spilling too many beans, can you give us a sense of the theme? Would they roughly be similar to what we've seen? 25% email errors?
Yes.
20%?
Yeah, I looked at the report this morning. We now do data breach reporting for our Audit Risk Committee report. And the graph that I saw this morning on your site looked very similar to the graph that I presented every 3 months to the ARMC committee, so that fascinated me.
That's interesting.
Yeah.
And I don't want to probe too deeply, but what about the sense of seriousness? Are you happy with the threshold that people are applying?
So we're just asking our staff to report everything, because even though it might not be serious for the customer, it could still be serious on another occasion. So the main purpose of the tool is for us to see what's happening and try to prevent something more serious actually occurring. But in terms of the criteria, I think sometimes I feel like notifications to the Commissioner's office, it can feel like too much to report one mildly serious breach that seems to perhaps technically meet the criteria under the Act, but it's only impacting one person. So sometimes I feel that legislation seems to tilt us to feeling like we should report, and I'm not sure that you'd really want to know about a breach that's being taken care of with the customer directly.
Thank you. And one last question on this for Spark. Do you feel that there is value to the company in receiving this information on a regular basis?
I think that there is. I think previously we'd focused completely on the safety of the customer and making sure they had the information that they need. But creating the tool has really given us a much bigger picture, and we're surprised at how many what I call minor incidents that we can really address through training or slightly different processes or controls. So it's been a really useful process.
Thank you. I'll skip to Sarah Thompson, and we'll come back to you in a minute, Rick, because I'm interested in you giving free legal advice to everybody. But Sarah, does that sound like a similar experience that Air New Zealand has been through?
Yes, very much. So I was very lucky when I started with Air New Zealand that because we're a global airline and subject to other jurisdictions, we have actually had mandatory privacy breach reporting as part of our culture since at least GDPR came in, and obviously a bit of a refresh when the law in Australia changed as well. So we did have, it was handed to me quite a good process in place for managing privacy breach incidents. and very similar to Spark, we have internal guidance. Anything that looks a little bit dodgy or like it could be a breach, we do require to be reported through the privacy team. We can then assess it, and we have a breach response process that kicks off if certain criteria are met around numbers impacted, potential sensitivity of the information, those sorts of criteria. I would say the OPC's tool, I think, has been very useful to us. A couple of those edge cases where we're looking and go, well, it impacts quite a few people, but the actual sensitivity of the information isn't very low. That's been a good way for the privacy team to cross-check and just test our thinking and go, we think this is probably one that's okay, but let's just use this to make sure we're not missing something and make sure we're aligned. Yeah, that's it.
Vicky, can I ask, given your international experience, are the reporting thresholds aligned across the jurisdictions in which you operate, or are you having to apply different filters?
Primarily, it's very similar, so across the main jurisdictions where we've had to consider this analysis, so obviously GDPR, Australia, there is that materiality. We did note an interest in California. Their privacy law just requires a blanket notification. It doesn't matter if there's any harm clause. So we have that built into our breach response process as we assess what information is impacted, which jurisdictions come into effect, and if there are specific requirements under those various jurisdictions, reporting requirements, that we make sure we're meeting those. Usually there does need to be a harm sort of consideration.
Thank you. Rick, as the Privacy Bill 2020 went through Parliament, this was the thing that attracted the most submissions. And most of the submissions were along the lines of, what the hell is serious harm? How do we know when we reach the threshold? Now, Parliament responded. The Select Committee suggested 4 or 5 criteria, which they enacted, to help guide decision making. Has that clarified things for the community, or are you still finding a lot of confused clients not sure how to, whether they've got to the threshold or not?
I don't know about clients, but I'm still finding myself somewhat confused at times when you look at it. Issues like, well, if this breach impacts X number of people, does that mean that it raises the seriousness of it? And that's not actually mentioned in the criteria, but it would tend, from an organisational point of view, to seem more serious if there are more people involved. Or do you simply weight it for sensitivity in respect of every single person, and then how do you do that when you're talking about a number of different people? So that, I think there are some issues around trying to work through that at pace, because obviously as soon as you become aware of a serious breach, you have to report it when you become aware of it, and there's quite a lot of work involved and quite a lot of difficulty in different organisations, and every scenario is actually quite fact specific. As I've found, I've been involved in probably 10 privacy breach situations, of which some of them have been notified to the Commission, others we've concluded that they weren't serious. But it is quite difficult still. I mean, I'm glad that they actually did put seriousness into the threshold, because of course originally in the bill it didn't have a seriousness threshold at all. So that was useful, and the clarification was useful as well. It's one of those issues. Do you try and define it, and you lose the sensitivity to areas that are not defined, where you try and provide some guidance? And I think probably the guidance regime is a better way of dealing with it.
I think that's a really interesting point that you make. What's the relationship between those different statutory criteria, and does the magnitude, the number of people affected, materially alter the seriousness when presumably the sensitivity of the information is objectively the same? My own view is that because of the inherent subjectivity and contextuality of privacy, the greater the number, the greater the likelihood that there is a thin skull in there, even given that you're dealing with what might on its surface appear relatively innocuous. So the bigger the number, the higher the likelihood that someone in there has taken extraordinary steps to try and maintain privacy for whatever reason, and would feel egregiously betrayed by the knowledge that something's leaked out. I'm not sure whether that's a very robust analytical framework, but that's my reckons. Staying with you, Rick, Oh, do we have any questions about mandatory breach notification? I'm not seeing anything on the Slido, so I'm assuming that means that everybody wants to speak up in person. We have some microphones.
I don't know whether you want to go any further on some of the aspects of it, but there is one aspect which I might as well raise now, which I'm finding fascinating from a geeky legal point of view and also from a practical point of view, which is the little, certainly to my point of view, the somewhat unknown provision in the Privacy Act, which is from the previous Privacy Act actually, and still made its way into the 2020 Act, which is section 11 of the Act, which deems an agent who is holding information not to hold that information, and for that information to be actually held by the agency. Delightfully vague and confusing wording for us lawyers to refer to agents and agencies, when in fact the term agent is not the agent in the normal legal sense of the word, but that's another argument. But the problem is that, or the problem or the issue is that when you start to burrow into that, what I'm finding is that it forces organisations to actually go through the contractual matrix in the same way that you had to do under GDPR and the processing versus controller requirements to work out what your contract said. It's forcing you to go through the same process with agencies and their agents, because if the agency, the holder of the principal, as you might call it, is deemed to hold the information and the agency, the agent, does not, what that means is that it's if there's a privacy breach, a notifiable privacy breach in your contractor, then you need to know straight away, because you're the one that is now deemed to hold that knowledge. You're the one that is deemed to have the responsibility to report, and you're the one, or your board might be the one, or your people involved may be the ones who are liable for an offence and not reporting to John through his personal email address. So I'm finding that's a very, very interesting and quite challenging regime, and what it's doing is forcing a lot of my clients to actually go into all of their contracts, renegotiate them, put in the privacy provisions that we all put in for GDPR, and have those discussions with people about, hey, if you find a privacy breach, you must tell us. You must not actually report it, because we don't know whether it's serious, and we don't want to necessarily notify until we become aware it's serious, and work through a whole protocol as to how that works. And that's actually quite complicated. If you think of even small organisations and how many organisations contractors hold their information, it becomes quite a tangled web.
So if you're using if you're a small business and you're using a booking system which is third-party software, and they have a breach, whose responsibility is it to notify? That's the question. And the answer is, it depends on the contractual arrangement. But the business, which is getting the advantage of the tool, might face the consequences.
Well, I'm not even sure that it is dependent on the contractual matrix, because the booking engine in your example is deemed not to hold the information.
Yes.
So the responsibility lies feeling squarely on the people who are using that booking engine to notify. And you don't actually want multiple random people deciding for their own point of view whether it's serious or not, when you're the holder of the information.
My point about the depending on the contractual arrangements is that if the booking agent doesn't notify the principal,
yes,
then and if there's no contractual obligation for them to do so, and they're not otherwise bound by the Privacy Act in New Zealand, then the principal, the small business, could be liable for something that they had no idea about.
Yeah. I've even got clients who never actually hold the information. The information is actually held, never comes into their hands or onto their servers. It's actually held directly by their contractors. So it's very weird to try and explain to them that, in fact, you actually are deemed to hold that information, even though it's not on your servers, it's on the servers of some web provider or whatever down the track.
Mm. Before we move on, sorry, Sarah.
Let's make it a bit more complex. So what we also find is with the customers that would like to, the corporate customers and organisations who want to renegotiate data reporting provisions, some customers, for understandable reasons, would like us to agree to not notify the Privacy Commissioner or any customers until they have decided whether we can or not. And that would be okay or make sense if it was only their individuals' information impacted, but then you have other corporates whose individuals might be impacted as well, with trying to put an obligation on us, we must report as soon as possible, which is our natural inclination, and we end up with a really complex matrix of how to keep our different customers happy, to support their privacy people and their customers, meet our legal obligations, and balance it out. Because once you've notified one party, you can't really not notify others. So yeah, it's a really tricky problem.
I mean, just a point from the regulator, because this is a new obligation, we are still at that thick end of the regulatory pyramid of influence. We're working with education and awareness, and if an organisation is innocent and is caught up in some of this complexity and doesn't know what to do and genuinely engages, I don't think they will be facing the full wrath of the regulatory regime in the same way that they might be expected to in relation to an obligation they've been under for 27 years. Just on this point, we've got a Slido question. What is considered a reasonable time frame from becoming aware of a breach to reporting it? Sarah Thompson, different jurisdictions that you operate in will have fixed, 72-hour requirements, or as soon as practicable, or immediately obligations. What do you think is a reasonable time for reporting?
Yeah, really, really challenging one, because they are often so fact specific. Obviously, as John's alluded to, we've got 72 hours for GDPR breaches, and because if we're dealing with something where we're having to notify a regulator in Europe, probably, our business decision would be we want to make the other regulators all aware at the same time. We sort of don't ever want to be in a situation where we've referred to one and they come approach John in his office and you know nothing about it in advance. So for me, it really is triggered by, you've become aware of something, how much do you know at that point? And what are the investigations you need to do to actually get to the point where you can determine, yes, this is something that's happened and it is serious, so it's triggering these thresholds. So I think depending on the nature of the breach, sometimes that analysis can take a little bit of time. It's quite interesting that under the Australian law, they actually kind of have a regime where that's incorporated a kind of assessment period to give you that freedom to go, actually, we need to work out what has happened here. I know,
and you can buy more time under that.
Yeah, buy a little bit more time. I mean, going back to my days at the office, I think it's, having seen quite a number of voluntary breaches coming through at that point, the damage you can cause by pulling the trigger too soon, if you are notifying things that don't need to be notified, or telling people notifications where you're like, a thing has happened, we can't really tell you much more, we're looking into it. How actually helpful is that to people, rather than being able to say, here's what's happened, here's what was impacted, here's what the risk to you is, and here's what we've done to fix it, or what you can do to fix it, I think is much more valuable. So it is a little bit of a balancing exercise, obviously as quickly as possible, and I think it was public, so I can talk about this, the Airpoints data breach in 2019. I know there were some concerns raised at that time about the time taken between us notifying the regulator, then notifying customers, which really came down to a early notification when we knew something had happened, and then as soon as we're able to identify the impacted customers, notifying them. And I think a learning we took away from that was trying to make sure we bring that as closely together as possible, because there were some questions as to why there was a gap between the two. So as soon as you can, tell them something meaningfully, but as I said, very context dependent, unfortunately.
What do you tell people, Rick? Someone comes running into your office screaming, we've had a breach!
Well, the first thing I think is to decide whether it's serious. And the whole purpose of putting that threshold in was so that we weren't overburdening the general population with completely meaningless notifications that their email had been breached, or a public piece of information had been leaked out. So I think it is incumbent on us to make sure that we do check that analysis first, and that we don't just do a knee-jerk lawyer's reaction saying, well, hey, let's not take the risk, let's just notify. So most of the work that I've been doing is in that space, is trying to work out, look, do we need to notify here? Notification through the notify us threshold doesn't necessarily mean, in your office, doesn't necessarily mean it's serious. So that's a way of at least getting it into the Privacy Commissioner's office system. You obviously have to characterise that as not being serious if you don't think it's serious at the time. But I think that that what I'm seeing, to come back to my long-winded answer to your question, is that if I was doing it, I would be saying to people, look, if we become aware that it's serious, then you have pretty good guidelines from overseas jurisdictions as to a time period that the society, in terms of the negotiation of those sorts of time periods in Europe, has decided is an appropriate time period. You wouldn't want to be going much beyond that, I don't think, once you've decided it's serious.
Excellent answer, and I'm very heartened to hear you offering that counsel of pausing and deliberating and really thinking through the implications rather than that default to, oh, I'm not sure, we better just tell anyway, because I do think that can be very undermining. And to take Sarah's point, if there's nothing that people can usefully do, you haven't gathered enough information about how they've been affected. All you're doing is actually provoking further anxiety and perhaps increasing the harm. Somebody's asked a question for me on the Slido. If 2 out of 3 reports made so far are not serious harm in your view, will there be adjustments to the Notify Us tool? No, I don't think there will, because the Notify Us tool sits on our website. It's a self-assessment tool, so it allows people to input their experience and get an estimate of our algorithm's opinion of whether they're approaching that reporting threshold. If it does, it says, well, we think this could be serious. Do you want to continue and report? And you can click a button which says yes, and it will drag in all of the data that you've input already and ask you a few more questions. If you say no, it drops everything. But there's also an option where the tool says, this isn't serious, what are you talking about? But do you want to tell us anyway? And a lot of people are continuing and filing those reports with us. And I don't mind that because our anxiety doesn't get raised by this. You're not reporting it to the individual. You're just saying, let's contribute our experience to the body of knowledge and maybe help other people avoid a similar experience. So the answer to that question is no. There's a question here from Jasmine which asks, the GDPR gives the regulator huge fining powers. Do you think fining powers in New Zealand act as a good deterrent to encourage compliance or too minor to bring change? I'm going to put that to the panel because what I think is less important than how corporates behave. And I'll again start from you, Sarah.
Sure. I think fines do make a difference, but to us it's really about customer safety, and that's why we've been reporting on data breaches well before the Act changed. And I think even aside from data breaches, other provisions of the Act, the potential brand damage, if you look at it from a financial perspective, the potential brand damage for a company that's breaching customer privacy or misusing information can be huge. And there's so many global examples, Facebook, and local ones even. It's very hard to maintain trust of customers if they don't trust you to look after their privacy. So I think in New Zealand, we're such a small country that brands stand for everything. So fines for us really don't make a big difference at all, but we do care deeply what our customers think of us every day.
Ricky, are your clients worried about fines? Do they say, oh, 10 grand, doesn't matter? It's not worth paying the legal fees on it.
I guess my views are quite well known on this point, which is that I regard that as a licence fee, not as a fine.
Right.
And I've asked you, John, whether we can get a discount for bulk. But being a little bit more serious, I do think we're miles out of step with the rest of the world, and yes, due credit to my colleagues here in organisations that uphold these sorts of ideals very well. There are plenty of people out there for whom a fine is really the stick that they need. There are plenty of carrots. I think we need a bigger stick.
Sarah, does Air New Zealand have a view on whether it needs to be fined?
I very much align with Sarah from Spark. We want to do the right things for our customers anyway, and that's taking care of our customers is such a key aspect of what we do and what we want to do for our customers, that we would never be in a situation where we're happy to pay the fine to do this thing, do something wrong. But I think the problem is not the people in the room or on stage today. It's the people who are likely to be persuaded by fines might require something a little bit more hefty.
I do think it is anomalous and noteworthy that if you leave a box full of 500 million email credentials out on the front step and someone comes and picks it up and walks away with it, if you don't tell me about that, you can be fined $10,000. But if you do, nothing. So, you know, I think that incentive is slightly run the wrong way. You know, I would like to see better incentives for that information to be protected. But it will be a while before we have another bite of that cherry, I suspect. Somebody asks, what help can the OPC offer to SMEs after they've suffered a serious breach? Well, we are on standby for your calls. We have people who are there to talk through what you can do. There is an organisation called ID Care as well, which organisations that experience breaches should be pointing customers to help them cope with the sequelae. And there was a much publicised case recently of a breach which enabled somebody to steal the identity of an individual, and she had a hell of a time trying to reclaim her credit reports and her credit worthiness and the like, refreshing identity documents, and achieved a settlement with the organisation, but just found that a really hard journey. So I do think notification is probably the start of the process when you experience a breach. It's not the end. And while we have emphasised the importance of learning from these breaches to re-engineer your systems and avoid them happening again in the future, I think you do owe a duty of care to those individuals to help them. What services can you provide? You know, can you get in touch with the credit reporting agencies and get a block put on their credit reports so they get notified if somebody tries to access credit? That sort of things. So that's a thought. What else should we be doing, do you think? Do you have any thoughts on that?
As a data breach notification?
Yeah.
I think exactly what you said. I mean, our view has always been to give customers the information they need to take any steps that will help reduce the risk. And so I think in determining whether to notify and what to say on our comms, we look at that and as a starting point, and then we check back against the Act and what it says. But we actually put customer safety first, and I think if you're taking that view, it takes you to the right place, and it's a lot easier for staff to relate to if they're supporting you while they've made the breach. They can understand what you're doing and right. Then you just sort of add on, sorry, but you add on the legal bit afterwards, in my view.
I'll throw you a Slido question, Rick. What are the thoughts on the likelihood of class actions via human rights review tribunal? I mean, we're seeing litigation funding becoming more of an industry, and we see that, I think, happening in this privacy space in the US. Do you see any signs on the horizon that there could be bounty hunters out there waiting to pounce?
Oh, I think it definitely. That provision was slipped in the SOP right at the last minute of the Act to allow class actions. So I think it's $230,000 per person at the Human Rights Review Tribunal. It's got a strange provision, which is the threshold through which you have to go to get there, relying on John to either do the right thing or do the wrong thing, or do nothing at all and be disappointed with that. And then you can go to the HRT. Because we know that the Human Rights Review Tribunal is terribly under-resourced, cases there are taking years to come out in terms of decisions. So whether a litigation funder is prepared to sit on their hands and wait for that result is another question. But I think, if there was a major data breach, privacy breach, then you can expect that there will be someone there looking to launch a class action, even if it's just to get a settlement out of my poor colleagues here.
We may be assuming more knowledge than exists, but up until now, the complaints mechanism in the Act has only been for the person who is an aggrieved individual, somebody who suffered the harm, or somebody on that person's behalf. But the provision, as Rick says, that found its way into a later version of the Act, allows for class actions to go to the tribunal. And that could mean, for example, this could be a rejoinder to those who are saying that, $10,000, it's a license fee. If you're saying that, somebody might get a $15,000 reward because they were included in a breach, and you multiply that by the 100,000 people who were involved in it, who are signed up for a class action, you start to actually look at some pretty significant financial penalties. So that will be interesting. What else do we have here?
So just to follow up on that, certainly advising most of all my clients, in fact, to make sure they check their insurance for that cover. There's nothing worse than finding that you're uninsured when you're hit with a class action.
Sarah Thompson, you have a very helpful contact, what do you call it, call centre. People ring up and they need to change their bookings or they've got a reference number. Have you had any experiences of people misusing personal information, impersonating people, stalkers, estranged harassers?
Yeah, that's an interesting question. Not that I'm aware of. So we haven't had anything come to our attention where it's someone deliberately trying to impersonate another customer. Obviously, we've had a lot of volume going through our contact centre in the last 12 months, particularly around refunds and cancelled flight changes. And where that's been more of an issue has been on group bookings in terms of who owns the booking, who can make changes, how does that work. We did, in advance of the new Privacy Act coming in, we made sure that we did have additional guidance for our contact centre staff around things they need to be doing when they're asking unusual security questions and making them aware that there's a new offence around impersonation. So how to escalate that if it becomes clear that that's what's happening, but to date I'm not aware of any cases where that's been identified.
We've seen it in utilities. In fact, there was a case, I'm not sure if it went to the tribunal or it just came through us, I can't recall, but a farmer who split from their estranged partner and went to a new location, got a new electricity connection, made it very clear that they wanted nothing to do with their former partner and no correspondence was to be sent. And the first bill with the new address on it went to that person who continued their campaign of harassment, driving by, actually forcing them to leave their share milking operation. And that resulted in, that wasn't a breach of the criminal standard of somebody trying to ring up and pass themselves off as the account holder. This was a misdirected email where the company had failed to update and correct those address details. And that resulted in quite a significant settlement. You see these kinds of attacks on your system from time to time, Sarah?
We do. It's increasingly difficult for people to pull them off successfully. We haven't seen many lately at all, but certainly we have in the past, and we know that people will successfully get through because they can be very ingenious and desperate and manipulative. We are looking at a policy as to whether we'll automatically report these sorts of attacks using the new provisions, but one of the things is that there can be a lot of complexity. So when you look at any individual case, I've had really sad ones where it might be a grandmother's granddaughter that's done this, trying to rip off her grandmother, but actually her grandmother still loves her. So her grandmother probably doesn't want to be reported to the police. So there's no sort of one-size-fits-all approach, but we're certainly very appreciative of the new provisions that enable it to be classified as a criminal offence, and we'll be using those as appropriate, but very much likely to be case by case.
I have some sympathy for organisations that provide, really strongly customer-oriented services. It's a really frustrating experience for a customer to ring up and say, "Hey, I've got the sense that I've got a bill outstanding. Can you tell me what it is? No, it's in my wife's name. What do you mean? I live here. I've been here for 40 years. I know, So you've got to strike this balance between providing that useful service and some security measures. And do you get a sense? How do you feel you pitch that? How many items of information do you need to get through the security checks?
Well, that's actually one of the interesting requirements of the Privacy Act at the moment. New references to account information and identifiers in the unique identifier provisions. And so you may have seen that the recommendation, at least, is that we try not to, as organisations, include account information numbers in the communications we send to customers. But for many customers, their account number is one of the key identifiers that they use to start that conversation. So if we stop giving customers account numbers and they've deleted the emails or they can't find their letters and so on, they don't necessarily have something with their account number to hand. And so weirdly it makes it more difficult to help a customer identify themselves effectively. So you're right, John, it's a very fine balancing act. So we really rely on CSRs exercising very good judgment and trying to support them to be very sympathetic to customers but alert to fraudsters as well.
If I can just add, so looking back to my time when I was at Westpac, obviously the bank with financial information, that's a hotbed, the sort of nefarious behaviour trying to happen. And one of the policies around identification was wallet to non-wallet. So asking a combination of questions between sort of your standard identifiers and things which only someone who already has access to the account would be aware of. So, where was your last transaction, or what's your balance limit, or that sort of thing, to try and avoid that situation where just because your wallet's been stolen or someone's got into your mail, they're able to get through enough security questions that they can otherwise access your details.
And do you find the impersonation criminal offence provide some support for your people on that?
I don't know if it adds anything extra, so I think obviously there's processes in place to just try and ensure that we've identified the correct person to begin with. I think the type of people who are likely to be engaged in that behaviour, they know they're already doing something wrong, and I suspect are probably not aware that there's also a potential additional wrong thing that they're doing under the Privacy Act beyond their behaviour otherwise being inappropriate.
I think it maybe can be useful. Occasionally, we haven't got it at the moment, touch wood, but there can be persistent stalkers who might be sort of chasing one particular individual, like an ex-partner, and so having the ability to tell them that that's what we're doing will be useful.
Yeah, and I think in your sector we've seen this, haven't we? Partners split, both had access to the email account.
And they know everything about each other.
Yep, and one is able to lock out the other or continue access, and had a really frustrating time closing down the account. We have a question from the panel, which I think is a very good one. Why has it been deleted? Oh yeah, here we go. To the panel, have you seen an increase in privacy requests from individuals because of the new Act? Can you provide insight, level of engagement and types?
We've seen more personal information requests, and we think that's in part usually good work from your office, John. We saw an increase in December, and we're expecting or planning for an increase this week going forward because of the privacy week. So I think it's a good thing that customers are more aware of what's available about them.
And what are they asking for?
Generally, they want back copies of bills and things. It's generally nothing really exciting. Occasionally, it's more interesting if there's actually a complaint between perhaps an ex-employee and employment relationship, or a customer who's unhappy with something. They'll be seeking information about the individual employee. That can be tricky to balance the privacy of the individual employee, but also make sure we meet the customer or the ex-employee's rights as well.
Rick, what do you think?
Well, obviously, I don't tend to get involved at that sort of level. It tends to be a bit more serious by the time it gets to me. But I can recount from when I was chair of NetSafe that some of the complexities around privacy information requests in fraud situations, particularly with relationship breakups, are very challenging, because on the one hand, you're required to provide that access to that information, which is a fundamental right under the Privacy Act, without which, in my view, many of the other rights can't be exercised. So that's why the access right is so sacrosanct. But on the other hand, you may have an individual for whom revealing that information could interfere with their own rights. So in a relationship property split, obviously, revealing information to a complainant may reveal information which endangers the safety or enables the other person to harass the other person, and so on and so forth. So that's quite a nuanced balance, and that balance has been strengthened in the new Act, which I'm glad about. But it is something that I had to look at before, as you know, John.
And in New Zealand?
Yeah, so it's been interesting watching. So we keep close track of the information requests that we do get, and we definitely noticed a quite massive drop-off in what was happening about March, April of last year, strangely. Although at about the same time, a bit of an uptick in people deleting their profiles with us, often offshore-based. I think we are definitely starting to see a few more. The volumes are creeping back up again, possibly because we're flying a bit more. But I think people are a little bit more savvy about their rights, and it's interesting to Rick's point. We are seeing a few where people are not just requesting, a copy of my airpoints statement or that sort of information, but are using their understanding of a right to request information to want to get more details about things. So,
why did I get kicked out of the Koru Lounge?
or you know, the information which, so that fine balance of information which is relevant to somebody but isn't necessarily about them. So this thing happened on the plane and I was involved, I want everything about it. You go, okay, absolutely, here's your personal information, but we do have privacy of others we have to protect as well. So trying to strike that balance of informing but not disclosing someone else's personal information.
Excellent. We at our office have identified as a priority area access because, oddly enough, it's been around since 1993 in the private sector, since 1982 in the public sector. People have this fundamental right, as Rick described, and I'd like to see it modernised a bit. I'd like to see a greater emphasis being put on proactively opening up files to people, to customers, rather than having them go through quite a mechanistic process to exercise that right. Maybe think about having a come and see your file day on Privacy Week or something like that. I don't know, there's ways to modernise this, and I think the business imperative for an organisation like Spark in New Zealand to automate this is utterly compelling, that I should have a portal I can log on, I can see it all myself. When you look at an organisation like Oranga Tamariki, which has 87 full-time staff dealing with access requests. Now that's twice the staff of my office, and that's one organisation. Look across at ACC, similar. So, you know, when you think about that investment of resource just dealing with here and now, it makes sense, I think, to be planning for your information holding and management practices 5-10 years out. When you upgrade your systems, can you put in a portal for people to use? So we're going to be looking at some of that and looking at the future.
Yeah, I think, if I can just comment on that, I mean, yes, but as we've all described, a lot of these decisions are pretty nuanced, and I wouldn't want to see some sort of automated, hey, plug your details in and you get all the information you can gobble up, just as a sort of an efficiency idea. Yes, efficiency is great, but I think we're seeing with things like artificial intelligence and some of the biases and so on that are creeping into that automating everything isn't necessarily the answer. And the other aspect of it, of course, is that we don't want to be criticised as organisations for making such tools available and then be criticised later when they're hacked and the cyber security of them is called into question by the same office that is now advising us to do it.
Excellent.
So I think just a caution there.
Of course, you would deploy full privacy impact assessment before rolling it out. But while you have the floor, there's a question directed to you. Have you found the model contract clauses helpful for compliance with Principle 12? You can be honest, you're my friend.
It's to me. I'll be honest and say not particularly. I know they were targeted at SMEs, but most SMEs have very little opportunity to negotiate with organisations that they're dealing with overseas, so that it's pretty much you get what you're given in terms of overseas providers of cloud storage or services that you're being offered. They're also quite legalistic, and it sounds funny coming from a lawyer, but I think it would pay to have perhaps something that could be slipped into people's terms of use or privacy policies that isn't necessarily a fully blown contractual matrix. And that's no doubt something that you've got on the burner already, John.
I happen to think that there needs an international solution for this. The system for data transfers is convoluted and complicated and broken.
I do come back to that point I made right at the start about agencies and agents. The provision in section 11 means that by and large most people who are storing information overseas may find that they're not actually required to have anything because it's not deemed to be disclosed, it's not transferred overseas, because they're deemed to hold it, and they're deemed to hold it in New Zealand. So the fact that it might be overseas is specifically called out in that section, and it doesn't matter. As long as the other organisation is not doing anything else with it, so AWS is a classic example, they're not doing anything else with it, they're just holding that information for you. So you don't need to worry so much. I mean, they have contractual clauses which comply anyway, but so a lot of people get really fraught about this transfer of information overseas when they're not actually transferring it under the Act.
think on
Yes.
section 11 it would be helpful if the legislation made it very, very clear that it doesn't require a traditional agency relationship. So at the moment, I don't think section 11 is used or relied on as widely as it could be by many of us because it's not crystal clear and take a conservative approach. I agree that most of the companies that are receiving New Zealand information are only doing so at the New Zealand organisations just processing on their behalf. But the processor control relationship that might be helpful overseas doesn't really seem to come into section 11 as clearly as it might. So it doesn't give us much comfort.
It was certainly the intention, but that it should mirror the previous provision, and there may have been something lost in the draft, and certainly not the only person to suggest that. We've brought it to the attention of the Ministry of Justice, and it could be something that gets clarified in a statutes amendment bill. I don't know. But the other, and I'm pleased you made that point, Rick, because in your example of model contractual clauses, you said something like, you've got no negotiating power with provider of cloud services. Well, of course, the cloud service provider, you don't need to have that negotiating power. The other thing I think which people may be missing when they look at that complexity of the international transfers is that if the agency to which you're making the disclosure is independently already subject to the New Zealand Privacy Act by virtue of the new extraterritoriality provisions, then also you don't need to go through that model contractual clauses or the due diligence obligation. But thank you for that question, and thank you for the frank answer.
Can I ask a follow-up question?
Yes, please.
How confident are you that the multinational companies will agree with the long arm of the New Zealand Privacy Act?
How confident am I that they will agree? That's a bit too big a question for me to deal with, because there are approximately 10 million companies that are subject now to the New Zealand Privacy Act. I just made that figure up, but I have no idea. We could name, the top 10 that spring to mind. They're probably most of them already would have been deemed to be subject to the Privacy Act anyway. I think it's reasonably clear that the application of the law, the enforcement of it is going to be another thing. And we saw this, for example, with the Commerce Commission enforcement action in respect of Viagogo. So there we have a company that is based in Switzerland, that is offering services in New Zealand in a way which brings it clearly under the extraterritorial jurisdiction of the Commerce Commission applying the Fair Trading Act. And they simply showed the hand and denied any jurisdiction until the matter got into court, and then somebody showed up and said that the Commission has no jurisdiction to make interlocutory orders. So it took a further appeal to the Court of Appeal before that position was clarified in the Commerce Commission's favour. But again, you still have a very difficult enforcement pathway, and for me to use the extent of the new compliance powers that we've got is to enter into a very resource-draining enforcement action to enforce a fine of up to $10,000 against a company which pays a $5 billion fine at a change from the couch. We have, somebody's added a question to the panel, which I think would be a nice one to finish on. And I know you'll all be fired up for it. And we'll start from this end, we'll start from New Zealand. Of the new changes introduced under the Privacy Act, what's the change you are most excited about, Sarah?
Changes I'm excited about. I find any discussion about the new Privacy Act quite interesting as well, because that was one of the things I started working on when I first started working at the Office of the Privacy Commissioner many, many years ago. So I've been living with it for a very long time. Most exciting, I think, is just the mandatory breach reporting, just because it's starting to brings us really into lockstep with what we're seeing in other jurisdictions around the world, and actually that helps get it taken a bit more seriously. Obviously, this is an issue for New Zealand directly, as I mentioned, we've had that for a little while, but I think that's done quite a lot to lift the collective consciousness about privacy in New Zealand, because previously it was a thing you'd have a few people aware of, but as that's come into effect and we've gone, actually this is a requirement of all agencies here, you have to step up and own it if you've had a breach. It actually just helps build the understanding and awareness, so that's been really exciting to see.
Rick, what's made you excited about the new Privacy Act?
Yeah, I agree with Sarah on the mandatory data breach reporting. I think that that's not so much for the notification itself, the process itself, but I think what it's done is enabled people like me and others to go to clients and say, look, there is now something you will have to do if there is a breach. And so no one can ignore it anymore, not to be fair that they weren't necessarily ignoring it, but it wasn't high on the priority list. So that's good. The other thing that I'm quite interested in and have found quite useful is the slight tweaks to the IPPs, in particular around necessary collection of information. To be able to go out to people and say, well, actually, why do you need that information, and therefore why are you disclosing it? It's a classic example the other day that I was discussing on my platform of choice around a notice that would have been put on the inside of a bus by a radio company, which said something like, hey, this was on the inside of the bus, so you're on the bus already. Hey, please be aware that you will be, and you consent to, being photographed and videoed while you're on this bus, and that we may use that material on any social media platform that we want. Now, the good thing about the new changes, it's probably a breach already, but I mean, the good thing about the new changes is that it enables you to go to someone like that and say, well, hold on a minute, why is it necessary for you, what was the purpose, why is it necessary for you to collect that information for the purpose for which you're collecting it, and beyond that, therefore, why on earth would it ever be necessary to use that information on your social media channel? And I think that's quite a good thing. It's only there are only slight tweaks there, but I think they've made it a lot clearer. And it also emphasises the fact, I think, that our regime is not consent-based. It's, there's a misconception that privacy is all about consent. Consent is only one part of how the privacy and the IPPs work, and that enables you to channel that discussion around more of this is a human right aspect rather than a consent contract aspect.
Thanks. And there were a few tweaks to those principles which I think largely flew under the radar, and one of them was in Principle 4, which says that you shouldn't collect information by means that are unfair or unlawful, particularly having regard to the age of the person, so the frailties of young people. And I think that strengthens things from the perspective of your other hat of NetSafe and making sure that young people are safe online and that good conduct is sort of modelled in collections of information. It's a softer model than kind of copper approach, but at least it's sending a signal out there that you've got to be extra careful when collecting from children. Sarah, excited?
Yes. So,
you're excited that all your competitors now have to do what you've been doing for years and disclose the breaches.
Yes, but to go along the geeky title attributed to me earlier, so in data breach reporting, really excited about the fact that there's recognition of the safety of individuals, particularly if you look at cases where a stalker has managed to obtain information about an individual. And so originally the data breach notification would have prevented organisations such as us from informing an individual in that situation of who had obtained their information. So we would have been able to tell maybe the woman concerned that somebody has breached your privacy, got your address, got all this information about you, but we can't tell you who. And so really excited about the fact that that was changed ultimately to enable in those situations where a woman's actual person's in danger, that the organisation can notify them who obtained that information. And secondly, I'm also excited about the criminalisation for people who are impersonating individuals to get their information, because again, that goes a long way to customer safety and making it easier for the police and organisations to try and stop those people who really are stalking or attacking people and using information for violent purposes. So that's what makes me really excited at a personal level.
Well, thank you, Sarah and Shera. That's been fantastic, and it's very generous of you all to come along and share your experience with an audience that's perhaps less imbued in it. So we're really grateful to you, and I thank you, and all the audience does as well.